Welcome to Identifying and Combating Witness Intimidation. This is part of AEquitas's series on prosecuting intimate partner violence. I'm happy to be here with my colleague, John Wilkinson.
Hey, Jane. Thanks for having me.
Absolutely. John and I are both attorney advisors with AEquitas. AEquitas is a nonprofit that is funded to provide innovative, informed, and hopefully really practical strategies to prosecutors and allied professionals who are tackling cases involving violent crime, but with a particular focus on crimes of intimate partner violence, stalking, sexual assault, and human trafficking. We do that in a number of ways, including training events like this, conversations like this, live large conferences, smaller, a lot of Zoom trainings these days. But we also have public facing resources on our website, which include recorded webinars, articles, research. We have some statutory compilations. So I encourage you to check out our website. But one of the things that I know John and I enjoy the most is that we're available to do one-on-one consultations. So whether that's wanting to soundboard with us about a particular trial strategy, or if you have case-specific research, we can do that for you as well. So please feel free to reach out. We're also involved in a lot of partnerships and initiatives. Those include things like the Sexual Assault Kit Initiative, the Enhanced Collaborative Model Human Trafficking Task Force, and Innovative Prosecution Solutions, which involve sort of interesting projects all around the country where prosecutors' offices are leading innovative strategies to combat violent crime, including things like domestic violence and trafficking. You can follow us online. We have several social media platforms where we're pushing out some awareness materials, new research, new training opportunities. So I encourage you to follow us. Today, we are really privileged to have the support of the Office of Violence Against Women, the Department of Justice. They support this work in this series, but not everything we say is necessarily reflecting their views. Because we want to give you the most innovative and sort of emerging information, we do that under our fair use doctrine, sharing, acknowledging the citations of others' work. So let's get started, John. I know that you do a lot of work with witness intimidation in the sense of context of intimate partner violence, but also sort of broader than that as well. So I'm excited to be talking to you about how we can improve finding it, identifying it, because we know it's happening, identifying evidence of it. And I know the theme of collaboration will continue through this conversation because it really does take that collaborative effect of working with the victim advocates, our law enforcement partners to proactively investigate, and then how are we going to effectively use that evidence in court. So hopefully we'll have that conversation today, but I wanted to start off with some of the research. And I know you're familiar with this. The first one being how intimidation kind of shows up in domestic violence cases almost as much as gang and drug cases.
Yeah, I mean, it shouldn't be surprising because we know intimidation is how abusers exercise power and control over, amongst many other ways, but that's how they exercise power and control over their victims. And so we should see it. It's the bread and butter of the domestic abuser: intimidate, make the victim feel uncomfortable, don't want to reach out, don't want to participate in the investigation or prosecution. Gangs and guns and drug crimes are also closely associated with intimidation, but I'm not surprised domestic violence is number one.
Mm-hmm. And the second study here then says within that sort of domestic violence sphere, we have some elevated risk factors that include financial dependency and continued contact because of shared parenting. So this should probably elevate our interest in proactively looking for intimidation in those cases as well.
Yeah, I mean, when we know there's going to be an association with a particular situation in our domestic violence case, we know there's going to be some sort of coercion, intimidation, things like that. But in these specific situations, why not ask proactively when you see that? We should be doing it anyway. But we know that there, folks, when you're forced together, it's just another way for that abuser to control you. And that access allows him to use his intimidation tactic against you. When you're separated, you're just less likely to fall victim to these tactics, or the offender won't have the opportunity to use them as much.
Mm-hmm. And that sort of goes into our overall theme here of this 5-prong process of countering witness intimidation. And I think what you're talking about is reducing the opportunities, but we've got to be doing all this other stuff as well.
Yeah, no, these are great. And just a simple thing to just think about in our practice, in our communities, where are there opportunities for this to occur and how can we reduce those? But you're right, all of these things are going to play into our comprehensive strategy to combat witness intimidation. So educating victims about witness intimidation, because they may not realize, if you're in a domestic violence relationship, that's your everyday life potentially. And so you may not recognize, oh, this could be evidence of a crime, or it could be important evidence for the prosecutors to know about because they'll be able to use it in the trial. Reducing those opportunities, the places that we control, where police and courts and judges and prosecutors are, we should really do our best to reduce any opportunity for intimidation to occur there. It sends a terrible message to a victim if we can't keep them safe in the very place where the offender is allegedly being brought to justice, or we're trying to bring them to justice, and we can't keep that victim safe because in the courthouse they're still getting, or the offender's family is getting at the victim. So we should look for ways to do that. We got to preserve that evidence of intimidation. So if we educate our victims and they know to turn it over, how are we going to preserve that without completely disrupting their lives? And I know you do a lot of work in that area. And that's where I've learned about this mostly, is because I don't think about those things, and they're important. It makes it tougher on the victim. I don't want to do anything to make it tougher on a victim to come forward when it's already tough, just because of the nature of the crime. And we're, of course, going to charge intimidation crimes, and then using that evidence of intimidation effectively in lots of different ways. So it might be to support a charge of intimidation that hopefully we can connect that charge with the underlying domestic violence crime or whatever crime you're investigating. It might be to explain the absence of a victim at trial, which is going to be a significant factor in our cases. If our judge or jury doesn't see a victim there, are they going to care about what happened to that victim? If they think the victim doesn't care enough to show up, why should I care? So it could explain their absence, and it could demonstrate that the defendant was guilty. He has a consciousness of guilt. Why would you try and make a witness, intimidate a witness, make them go away if you did nothing wrong?
And I think it's important to sort of separate using that evidence effectively and charging intimidation, because every state's intimidation statutes look very different, and some of them are not written in recognition that intimidation is something less than overt threats or harm, physical harm. So you might have a course of intimidation, but it might look like emotional pleas. And we'll talk about that. So you really can't charge intimidation. It's not fitting, but that doesn't mean we can't use it effectively in these other strategies.
Right, exactly. And if it does fit, if our particular charge of intimidation or witness tampering or obstruction of justice, whatever it's called in your jurisdiction, is broad enough to include that activity, let's charge it. If it's not, we'll still use that evidence in our case.
And there's some other charges too. I want to make sure we know what's in our tool belt, because like stalking can sometimes be charged, property crimes, computer crimes, harassment, blackmail, bribery. I mean, there's a lot that can go into that. So thinking more broadly as well, because we know, and this comes from the study, Meet Me at the Park, where we meet. I always get that wrong. Meet Me at the Hill, where we used to park. but the recognition that perpetrators are not threatening the victim necessarily in domestic cases, but are using these sophisticated emotional appeals that are designed to minimize what happened, right? So that's part of the power and control wheel. Earlier spoke by spoke presentation in our series, but the goal of that is also to gain the sympathy of the victim.
Yeah, and I think it's really good to bring this up because I think this is happening more often than the "I'm going to kill you." That happens too. When we find it, it probably fits everybody's statute. This is a little trickier and a little different. And I want to make sure that the victim is aware that this might happen and that we learn about it. Sometimes we only learn about it through proactive investigation. When we educate victims, they might turn it over to us or share it with us. But this is what's going on. So we have to think of intimidation in a very broad way. It's not just the threats. It's not just physical violence, things like that. It is other things as well. Anything that is designed to make that witness go away, basically.
I like that broad definition. Anything that's designed to make the witness either not appear or file. We used to have, these null pros affidavits that we'd get that was at the direction of the offender most of the time.
Right.
This study's really what they did. Speaking of proactive investigations, they listened to, I can only imagine, hundreds of hours of jail phone calls.
Right.
And I'm sure you've done that in your practice as well.
Yeah. So the jail phone call is going to be a fantastic resource to find things out. But I think you're right. They listened to hours and hours and hours of this and saw that this was playing out, amongst other things, I'm sure. But that this was the tactic that was being used to get out from under criminal prosecution. The defendant knows their victim better than anybody. And so they know what is the tactic that's going to be the most effective. And so those power and control wheel tactics, they'll pick that one that's going to hit. And this is one that I think is a very common one. Please don't come to court. I love you. I'll change. That's an effective one.
They know what button to push.
Yeah, absolutely.
Yeah. So if it was financial control in the course of the relationship, then the threats and the intimidation is probably also going to be related to some sort of financial situation.
Or multiple. Why not shotgun the whole thing and we're just going to hit every button possible? It depends how desperate that offender is.
Mm-hmm. So this is what they came up with, this sort of five-prong process. And they observed that at first, a victim may get on the phone and they're strong and they're resolved. And sometimes we see this in our first meeting with a victim, right? This sort of sometimes referred to as a golden hour, where victims are able to disclose, maybe because there has been a systematic response and they're feeling that level of safety and they're feeling strong and resolved. But then the sort of continues on, and then we see this offender first off minimizing the abuse in some way, which could also be like denying or blaming. And then importantly, kind of casting themselves as the victim. And this is a real, I don't know. I don't want to say they're good at it. It's not a good thing, but it's amazing how effective they can be with that.
Oh yeah, I know. I think it is. And it's just sort of, it just is so frustrating to see this and it is effective. And sometimes we have trouble responding effectively to it. So I think we definitely, I love the way this is laid out because it really is a roadmap to how this is going. And so when we do have access and opportunity, let's take advantage of that to counteract this in any way we can. And so when you talked about that golden hour, when that victim is strong and resolved, often at the scene, they've called the police. They recognize what he has done is awful, wrong, violent, and they're sharing as much information as they can. We want to get as much information from them about what happened during that golden hour. And we want to give as much information as we can about the resources we have to support them. So hopefully they don't start down this path. And so we can interrupt this particular offender strategy to get the victim to not participate in the investigation and prosecution.
Because right after this, it becomes this, they don't understand us, which quickly turns into, it's us against the world, therefore you need to do this for, not even, I wouldn't even say lie for me, I'd actually put in here, lie for us.
Yeah.
Right.
If they're effective, that's what they're going to say. If they're really effective, that's what they're going to say. And so, yeah, we want to just try and engage that victim as much as possible. Victims, over time, they do sort of drop out of the system. Victims engage in their own safety planning, so it could be part of that as well. And so victim safety is first and foremost. I tend to think they're going to be safer away from that person in the long run, but they have to make those decisions. They know this individual better than anybody else, including us too. So we just have to be as supportive as we can with those victims.
Yeah, and I appreciate you saying that, because I do recognize, especially earlier in my career, I felt like I probably was like, oh, this is what you have to do to be safe. And instead of listening, like, how can we make you feel safer? How would you feel safer? What would make you feel safer? And sometimes contact with the offender is a process of them keeping themselves safe. Like,
yeah,
I can manage him if I know what's going on. If I, call him once a day, I can kind of take his temperature, and that can keep me safer than no contact whatsoever. And
yeah,
so listening to them and sort of going, okay, well, then let's develop a safety plan around that, or I don't know, just being more responsive to where the victims are and what the victim, because they know better than us. That's important to remember, I think.
yeah, and just making sure that we're engaging with them, because I often also think that people just don't recognize that there might be another way to live your life. And so if we're engaged with them, we have those opportunities to say, these are the resources we have. Or, some of the domestic violence brochures, like the one from the Denver DA's office that lists out the things that they're likely to hear. Those are important. Oh, and you've got it right there. Because that's how they're going to recognize, oh, he does do this, and they know this, and they can help me. And we can hopefully get them off that path. Even when they're making those decisions for themselves, we can participate in that process as well, and help keep them as safe as possible.
Yeah, because this goes to like even that, 5-part process. I feel like educating a victim on that and say, like, this is how it like it's usually happens. This is what the research shows us. And then maybe coupled with a resource like this one from the Denver City Attorney's Office, where they actually said, hey, watch out, this may happen. And they put it in quotes in the offender's likely words. I can imagine, maybe not when they first see it, but then they get that call, they get that text, and all of a sudden it's like light bulbs could go off, because they told me this is what he was going to say. So this is the resource from Denver. It's 2-page. I mean, it's a 1-pager. We have it split between 2 slides here. But you'll, if you show up to court, you'll pay for it. Yeah, that might be an overt threat, but maybe something else. What I would hear as much more often is if you don't show up to court, this will all go away. Yeah. So I love this. I prosecuted in Miami on the latter part of my career doing human trafficking work. And we actually, after I left, I shared this resource with a colleague, and they adapted it for trafficking. So I think Denver is very generous with this, and the idea of sort of maybe adapting it for your own purposes. I know you worked really closely with Baltimore and their program on intimidation, and we've got their resource here as well.
Yeah, and so we didn't do the quotes thing, which maybe that would be a good way to adapt this. And we do have a template for this. If anybody wants it, they can create their own witness intimidation one. But we did work with Baltimore and tried to identify things that would likely happen if you were participating in a crime as a witness or a victim, particularly domestic violence, gang, gun, and drug crime. And it lists out things that would happen, examples of what intimidation might include, and the services that the state's attorney's office had to help. And then, of course, also call 911 if there's anything going on. And the tip, please save any evidence of intimidation going on. So just trying to help those victims help themselves if they're caught in this situation. And very much like that Denver city attorney's one, I just feel like if those light bulbs go off, that you're going to be much more likely to call that number than, if no light bulbs go off or nothing, it's just a brochure. I'm never going to read it or anything like that. That one just is a little more encouraging.
Yeah, if we just ask, have you been intimidated, or is the witness intimidating you? Because this says, on this one, it also includes threatening to take away money or promises to give money, gifts, or favors, because that we see that other half of it a lot. And so letting them know what to expect. These are great resources for that. I also learned I needed to have this conversation every time I met with or talked to the victim, not just once.
Right. And I think that's 100% true. And, if we're talking about domestic violence, your opportunities to talk with your victim, you may not have multiple opportunities, but if you do, particularly in our serious felony domestic violence cases, I'm going to be meeting with that victim multiple times. And I definitely want to go over what's going on. I definitely want to touch base on, has the safety situation changed at all? Because these cases aren't static. And we know that the intimidation, it might be ramped up right after a charge, but it might not ramp up until right before trial. So things change. It's not just a sort of, oh, we've got our safety plan, you're good for the rest of your life. Things change. People are locked up and get out. People may not be locked up. If they're locked up, that doesn't mean they're not going to get at that victim. They have multiple, allies, family members in domestic violence. I think some of them may do it unwittingly, and some know exactly what they're doing.
And while, I think one of the things that I saw was, because there was a normalization of some of the behavior, victims would say, like, well, I didn't want to bother you because I received one text. Or, I'm not going to call 911 when, he just, obviously stopped by and left something on my porch. So there's this balance of, I don't want to minimize that contact, but I also want to let them know, if you are in danger, call 911, obviously. But there's also, like, I still want to know about it. Like, how can you share that with me, or keep a log? So some of those strategies with stalking can kind of help in this regard. Maybe some really basic conversations about how to screen save something, how to screen record something, or take a picture, or to save things. I think those kinds of conversations, because unfortunately, they're the best person to collect this evidence in situations like that.
No, I know. And that evidence is going to come to them, right? Because they're the target. If I'm going to get out of this charge, I have to intimidate. Broad definition of intimidate: do something to make this victim not testify or not cooperate with the police or prosecutors, what have you. So that's going to happen. And I think you also made a great point about, I just think it's human nature. People don't want to call 911 anytime something happens, right? We just tend not want to do that.
The other way.
So it could be the other way, yeah. But I don't know. I've just had experiences where, like, you're hurt or something. It's like, oh, I'm okay. I don't need to go to the hospital. I don't need to go. And you probably do sometimes. But it's the same thing. But having someone that a victim can call that's not 911, so that that will get a response. So it is as reliable as calling 911, where someone's going to pick up the phone. You're going to get a response, even if it's not immediate. You're going to get a response as soon thereafter as possible. I think that's really important because that's a way that victims can share information with us. It might be something that is not super serious. It might be something that is super serious. So we want to know, or important evidence, or it's just more information. It's also building that rapport. One of our colleagues, Patty Powers, talks about rapport. Because it just clicks with me because I would do this. It's like rapport isn't something you do for 10 minutes when you meet somebody. It's an ongoing relationship with somebody and how you interact with them continuously over a period of time. And it just always resonates with me. And having that ability to get back with victims who don't want to call 911 every time something happens is super important.
Well, lucky us, I actually spoke to Patty about rapport building and it, not being like a checklist. It's not like 5 questions. How are you? What was the weather like? Okay, now let's talk about this violence. Yeah. And I can, if you know Patty, she was probably very effective at doing that.
Oh yeah.
It's amazing. The other thing I want to talk to you about is resources to cover expenses, including relocation. So, short of the U.S. Marshals Service putting you in a witness relocation program and providing you with plastic surgery, what are other sort of like local level resources that are out there? Because I don't think people really know that there are more than you might imagine.
Oh yeah. So I think, what is our victim situation? We want to make sure we understand what the safety concerns are, what credible threats exist. And in domestic violence, it's almost always going to be a credible threat, right? These guys are dangerous. So does the victim want to relocate? Some victims will want to, some won't. And for lots of different reasons. I can't take my kids out of school. I have a elderly parent that won't move, or it's their house and things like that. And so can we keep them safe in place? And can we do things to check locks? Is there a simple alarm system that can be purchased? Can we do safety planning about their routine to keep them safe in place? If we do want to relocate somebody and we don't have a formal witness relocation program like the Marshal Service or your statewide program, are there other places at friends or family that a victim could relocate that the offender might not necessarily know to go check? Is there public housing options that a victim could, if they're currently in public housing, they could advance to the head of the list to move to another unit somewhere else in the community or in the state? Are there options along those lines that can help us do sort of informal / formal relocation? And then if we really do need to move a victim and use our funding, but we don't have a formal witness relocation program, do we have victim compensation funds available that we can access? Or does our office have funding? Like, we used a lot of our asset forfeiture funding for different things. And so sometimes we had that money. There's rules about what you can spend it on and what you can't. So you have to pay attention to those rules. And but that might be a source, like, hey, we can put somebody up somewhere for a while until this other option becomes available, or until we can find a more permanent solution.
Mm-hmm. I think there's some creative ways that we can do this, even in under-resourced areas. And sometimes it's just a matter of knowing what are the resources available, and collaborating with your systems-based folks are usually the best with that. But there's some community-based folks that they'll have private funding, or they'll have a donated, cameras that people can put at their houses that will help them feel more secure. And there's lots of things that I think are short of the U.S. Marshals program that we need to make sure we're aware of.
Yeah, that collaboration really is key. They have so many resources that we don't necessarily know about that they can offer. They take a lot off my plate. They make my job easier, and it's just great to be part of a team. The team. I didn't win every case I had, and that team was there no matter what. Come out of court, and they're supporting me. The cases we won, it was a huge celebration. Cases we didn't win, the team is there. We'll get them next time. We need to change some of the things, how we did this, blah, blah, blah. It's just great to have that support.
Mm-hmm. which is a great segue because I want to talk about those places that we do have some level of control over, and are we doing the best we can to make victims safer in the courthouse, the courtroom, because we know it's happening right there, and that's got to be the biggest sort of almost like slap in the face.
Oh,
If
yeah.
you're in the courthouse, in the courtroom, and offenders feel free to intimidate.
Yeah. And when we train on this, we usually ask the audience, has anybody had intimidation going on in the courtroom while a victim is testifying, and hands go up. So, I mean, it happens. And look, our court security folks, sheriff's departments, most of the places I go, they say they do a great job. They're just very good. They're on top of things. This kind of intimidation, which can be subtle and different, might not be on everybody's radar, even though they do a very good job at security across the board generally. And information that we possess about a case might be important to share with the court security folks so that they are able to keep an eye out. But things that we want to do in our courthouses is really do a sort of physical assessment of, like, what is the space like? Where are victims and offenders, or families of offenders, or allies of offenders forced together? They are going to be together at court. Every defendant has the right to confront and cross-examine the witnesses against him or her. And so we know they're going to be together at some point, but where can we keep them safe, even in these places where they have to come together? Physically, do we have separate locations for them to enter and leave the courthouse, or to congregate while they're waiting for their case? Where are they before they get to the courthouse? Do they need accompaniment with someone to get them safely to and from court? Some need transportation, and some advocacy organizations do great court accompaniment and can help with that. How do we keep them safe? Keeping them safe on the stand, I think, is important. Like, we're not going to let defense attorneys have a free-for-all against a victim on the stand when they're testifying. We'll object when appropriate. The situation where you have a pro se defendant, we may need to do a motion to ask the court to appoint counsel for the purpose of cross-examining the victim, because it would be inappropriate to subject the victim directly to questions from the defendant. So those are all things that I think come under the big umbrella of victim safety and opportunities for intimidation. So working closely with our court personnel, security personnel, is important. Also, to sort of have a protocol for responding to intimidation in the courthouse and in the courtroom is important. So they might want to, the first measure might be to interrupt something that's happening that shouldn't be happening. If it continues, then you might want to pull that person out of that location and document it. And so, because it might be information that we as the prosecutors can use, or it might be something that we bring to the court's attention and we want to put on the record that, hey, we're asking that this individual, not the offender is going to be in the courtroom, but maybe it's a family member or a fellow gang member or something like that. We want them excluded because they have engaged in this behavior, and we've documented it. And so the court can make a comfortable decision to exclude somebody when they have that on the record documentation.
Because it's, obviously constitutionally protected to have a public trial, but like most constitutional protections, it's not limitless. And so there's some really great case law that says, okay, when there's a record of this, these, sort of measures to keep people safe are absolutely appropriate. And so, if you have it documented and recorded, you can do things like excluding someone. Or one of the cases I read recently, which I frankly didn't know about, was when documented, and I think it was a gang case, the court required everyone who entered the courtroom to show their ID, basically saying, intimidation happens when there's anonymity, and the requirement to show your ID was not overly intrusive to keep the victim and the courthouse and the courtroom safe. And so to know our tools, you may have to educate your judge on that, and then lay the foundation and lay the record when it's appropriate.
Yeah, I agree 100%. And your judge is going to be able to do those things when they have the evidence necessary to support those decisions.
So what are things that we can do when we've identified intimidation from the outset?
Yeah, I mean, I think you've said this earlier. We definitely want to take these reports seriously and respond to them. So it could be something like we're going to revoke bail or bond. Perhaps the individual is already incarcerated and is engaging in this, or is directing others to engage in this. So we may have to deal with that situation and talk with our jail about how can we curtail or better supervise what's going on, because it's difficult. You know, these guys trade PIN numbers. They're going to get at that victim any way they can. So we want to make sure our jail intelligence folks are on top of this. So we might need to alert them to that fact. If they are at large, we want to modify their release conditions if intimidation is going on. But honestly, in a domestic violence case, of course, that should be included in any original release conditions. And the other thing that might be important, particularly in a criminal case where there's a criminal no contact order, as opposed to, say, a protective order, the criminal no contact order might not be accessible to law enforcement the way a protective order is. And a victim may not have a copy of that order, as we always advise victims to carry in a protective order situation. So you might want to think about ways that your criminal no contact orders can be memorialized and shared with victims and with the law enforcement. So when there is a report that there's a violation, law enforcement can act, if your jurisdiction allows immediate arrest for such a violation, or act in whatever appropriate way there is in your jurisdiction.
Yeah, I think you made an important point of differentiating between the civil protection order, sometimes referred to as like a restraining order, and an order related to the criminal case, which of course sort of goes away when the criminal case goes away, where the civil doesn't. And sometimes, so I was lucky to prosecute in a jurisdiction where violation of a pretrial release order in domestic violence cases, that in and of itself was a new crime, a new misdemeanor. That's not the case everywhere, so it's important to kind of figure out the lay of your land. The civil protection orders violation is usually criminal, can lead to aggravated stalking charges as well. So that could be one of those additional crimes we could charge. And then I think an underutilized tool we have is contempt, which is something both criminal and civil judges can, they have the inherent power to enforce their own orders. And usually those contempt proceedings can be done on a quicker scale than, let's say, a new criminal case. Mm-hmm. And you know, there's minimal, but that could include additional jail time. And it could be something you could do for someone that was already in jail. So kind of trying to understand how contempt works. I don't think it's incredibly utilized. We did it a couple times when I was prosecuting, and I found it effective. I found that it really sent a message that we were taking things seriously, because there was this sort of immediate and pretty strong response. And then charging those additional crimes and looking beyond just intimidation, right? So we mentioned stalking. One of the series in this, one of the presentations in the series is going to be specific to stalking. We also had fun things that we charged, like, well, I don't know if this is possible everywhere, but ID theft. We were able to charge that when the prisoners were using different ID numbers, the PIN numbers from different people. So you just got to kind of, I know maybe I'm just weird, but I like looking through the statutes and being like, oh, I never knew that statute. Oh, that could work. Oh, I could see that. So
I think that's your human trafficking brain, because you had to figure out solutions to problems. And I think that's a brilliant solution. You know, that may not work everywhere, but have you looked at it to see if you could? I think it's a great idea. They also, you know, the charging the additional crime, say the intimidation crime, and marrying it up with the underlying domestic violence charge, say, is another great one, because at that bail or bond hearing, I'm going to argue, you know, that this is a new crime, this intimidation, and it's related to this existing crime. So he's committing a crime to evade accountability for the original crime, making it doubly bad. And this is somebody who really should not be at large or have the ability to contact this particular individual. And charging those associates or family members who are doing the dirty work for the incarcerated individual. And it doesn't even have to be incarcerated, right? They're going to send, he could be out and send his family member over to, send a message, get that person to change their mind. But to hold those people accountable too. It's not always easy. It's going to depend on the facts, but I don't think we should turn a blind eye, because some of these people are doing it intentionally, knowingly, and trying to implicitly or subtly, not so subtly, intimidate that victim.
And it shows the systematic response that that is like, this is something we take seriously, and we know that intimidation is so pervasive because it has worked. It works. And so if anything we can do to show like this isn't going to work here, not only is it not going to be effective, but you're going to get yourself into more problems. Instead of getting yourself out of this problem, which was your goal, you've now got yourself into hotter water, I guess. But it does work. Despite, all these strategies that we should always be employing, we also, I think, have to be aware of and prepared for intimidation working, and us being in a situation where we have a victim that's really not able to participate. So what can we do in those situations?
Yeah, so we do want to think about, particularly in domestic violence cases, because this intimidation is ongoing, and probably precedes the charge that we're talking about. We have to think about that and think about how we're able to go forward, because we know that some of our victims are just not going to be able to participate in the investigation and prosecution of the case. So what can we do to make sure that we can go forward? That evidence-based prosecution is going to be the key that we should be doing in every domestic violence case. I don't want to have to predict which victim is going to show or which victim is not going to show. So we do it, investigate the case the same way every time, document everything. That evidence-based prosecution is essentially anticipating that we may not have a victim come time of trial, almost like you would investigate a homicide trial. Our victims likely to just fail to appear, or refuse to testify or recant. And so if we've documented everything, body-worn camera footage, photographs, if you don't have body-worn cameras, photographing injury, lack of injury, the scene, disturbances from the scene, or whatever the scene looks like, statements, getting those statements from both the victim and the offender and any witnesses. Sometimes kids are present. And so, we'll make a decision whether it's appropriate to call a child in any particular case. But if you don't talk to that kid, then I just don't know if they know anything or not. And I just can't make an informed decision. So things like that are going to be super helpful. The 404B evidence, other crimes, wrongs, or acts evidence, is super important. One of the things you always point out, Jane, is it's not prior crimes, it's other crimes, which is a really important point, because I think that's where we look. And naturally, you're going to look in the past, and that's in domestic violence, you're going to find a lot of that stuff. But that's not the only place you'll find it. It could be something that happens after or subsequent to the incident that we're talking about, or the incidents that is charged. So you want to look, and it doesn't have to be a crime. It could be something that they do, one of those power and control wheel tactics that we've talked about, that is they're engaging in. That's going to be important, relevant evidence to demonstrate that this was done intentionally by the defendant, that he had a motive to engage in this behavior to stop the victim from doing something, reaching out to police.
Yeah, and some of those like things that don't rise to the level of criminal behavior are sometimes the most sort of those little nuggets that really get you there, like monitoring somebody's odometer. Like that's not criminal, but that sure gives you very succinctly a look into the nature of that relationship.
Yeah, there was a case, I think it's out of Tacoma, Washington, where the abuser would make his wife weigh herself every morning when she got out of the shower. And it's just sort of like, okay, that's something a judge or jury is going to recognize instantly. That's not a crime, but anybody can recognize instantly. That's not what I think is normal in a relationship. Something else is going on there.
Yeah.
So we can use evidence of the intimidation to demonstrate that consciousness of guilt. Why are you going at this person with, I'm going to change, I love you, just don't come to court if you didn't do anything wrong. We can use experts to educate judges and juries on the victim's response to the trauma of domestic violence so that they understand things that victims do when they're in a domestic abuse relationship are not reasons to disbelieve them. They're things that are typical. A victim could respond in any way, so we can't predict all of them, but we see some common ones: staying with the offender, minimizing what happened, recanting, failing to appear, things like that. So it helps us educate those fact finders when we do that. Charging those co-occurring crimes, and forfeiture by wrongdoing, which I think we're going to talk about in a minute, is a really powerful tool that we should be using more and more. It's not going to work in every case, but it's just that theory that says if the defendant does something to make that witness go away with that intent to make the witness go away, that witness's statements can come into evidence.
And I don't think I'm like overblowing it if I were to say forfeiture by wrongdoing is one of Equitas's favorite things to talk about. So this is the federal statute. It's in their hearsay 804B6. Most states have codified it, and you're going to have an evidence code that looks very much like this. There's a few states where it's by case law. No states have sort of rejected the premise. I think, you've got the reference here of the language of the statute, but I think it's the quote from Reynolds v. US or the United States, which is the seminal case, that really tells you what it's all about.
Yeah, and so this is a case from the 1800s. So this has been around for a long time. And it's basically saying that you can't do something wrong and then take advantage of that wrong in the criminal justice system. So whether it's you call it an equitable solution or equitable estoppel or a clean hands doctrine, like you can't create error and then seek to benefit from that error. And so that's basically what forfeiture by wrongdoing is saying. It's that every defendant has the right to confront the witnesses against him, right? We have that Sixth Amendment right. Everybody has that right. If you do something to make that witness go away, you can't then come to court and say, hey, where's that witness? I want to confront and cross-examine them. And that's basically what they're saying. So the defendant has engaged in well, the victim's unavailable. Sometimes we don't know this until the day of court. And sometimes you don't know it until you call that witness to the stand. But that victim is unavailable, meaning they failed to appear. Obviously, sometimes victims are murdered. The victim has feigning memory loss. It could be actual memory loss. The victim refuses to testify. Those are the situations in most states where their code codifies that the victim is unavailable. And the defendant has done so wrongdoing, has done something to make that witness unavailable, that victim unavailable. And the wrongdoing doesn't have to be the threats, the physical harm, things like that. It could be the I love you, please don't come to court. If you don't come to court, this goes away. So you overhear that on a jail phone call, bam, I want that. I'm gonna use that in my forfeiture by wrongdoing motion. And then that third element is they just have to intend that the witness become unavailable as part of their activity.
And it doesn't have to be the sole intention, right? We've seen a couple of cases where the courts have said the defendant could be doing this for a couple of different reasons, as long as one of the reasons is also, I'm going to get out of trouble. I'm going to, this victim's not going to come to court or be able to testify. And they've said, this is typically a circumstantial argument that we're making. Sometimes we have that maybe silver bullet of a jail phone call and a statement by the victim, and it's sort of easy to put it together. But a lot of times we're connecting the dots. We're making rational inferences based on not only maybe jail phone calls or with testimony from friends and family, but also bringing to light the nature of the relationship and how the whole course of the relationship, the defendant showed an intention to prevent the victim from disclosing, from telling others, from going to the police. And so this time was very likely the same intention.
Yeah, and so that isolation essentially from the power and control wheel is exactly what we're talking about. And when you have evidence of that dynamic, that tactic, that's going to support this forfeiture by wrongdoing motion. And the other important thing to remember, because as you said, it's typically going to be that circumstantial evidence. Sometimes it could be the witness is going to be unavailable. So what has the witness told us previously? I'm terrified of him. He keeps threatening me. I know he has a no contact order, but it doesn't seem to stop him. And so I can't come to court. I'm terrified. So you might have that kind of direct evidence, but it's more likely going to be more circumstantial. And so one of the important things to remember, in most states, not every state, the standard of proof for a forfeiture motion is preponderance of the evidence. So more likely than not. Unfortunately, Washington, New York, and Maryland, it is clear and convincing evidence is the standard, which isn't impossible. So you can still do it, and they do still do those motions there. But preponderance, more likely than not, is a huge advantage. And so we want to make sure that the court recognizes that's the standard of proof for this hearing, that where I'm going to present evidence to convince the court that my witness is unavailable because of the defendant, his intentional actions to make my witness unavailable. And therefore, I want these specific statements to be allowed to come in that we are aware of that the victim made.
And you also pointed out, as far as like, what does this hearing look like, that they're not bound by the rules of evidence. Therefore, the victim's statements, when they're telling us they're afraid, those statements can be admitted in the pre-trial hearing to determine whether we've met the burden of forfeiture by wrongdoing. I think affidavits would be admissible. So we've got a lot of room there as well to make sure we're able to demonstrate to the court the likelihood of the defendant's wrongdoing being the cause and intention behind it, of the victim not being there. And sometimes I've seen judges, they don't rule on it. They hear it in advance and then they'll wait until see, okay, is the victim going to show up or not? Because we don't really know. So sometimes they're held in abeyance, or, the ruling is what's the word? That's just deferred ruling, I guess. But this is someplace where I know AEquitas can absolutely help you guys if this isn't common practice or you have that case. We have model briefs, and a lot of us have done a lot of work in this regard. I'll show you some additional resources in a second, but first I wanted to thank you, John. I think based on this conversation, I think folks are going to maybe go forward and be able to not only identify that overt, but the subtle forms, and help the victims they're working with also identify that, and then be able to say, okay, we've identified it, now let's investigate it, let's preserve that evidence, and then use it for our benefit instead of the benefit of the offenders. And one of the ways to do that is the forfeiture by wrongdoing. These are a smattering of our resources related to intimidation, forfeiture by wrongdoing, and other creative strategies to go forward on these cases when we do have the evidence of wrongdoing. So this is me. You guys all know how to get a hold of me. Again, this is John. I really want to thank you for your time today.
Thanks, Jane. I really enjoyed it.
And we'll leave you with one last pitch for AEquitas's office hours. Happens the third Thursday of every month from 2 to 4 in the afternoon. Different topics are brought up every month, but really it's an opportunity for you to sort of build a community and network with other prosecutors that and allied professionals that are doing this really challenging work. I know we've talked a lot about emerging issues. There's been a lot of COVID conversations recently, so I encourage you to register and participate in our office hours. Thanks a lot, everyone.